Good evening, everyone. Welcome to JTS for the Bernard G. Siegel Memorial Lecture in Law and Ethics. It's my great pleasure and honor to be joined by tonight's speaker, noted legal scholar Frederick Lawrence, whose topic will be free speech versus hate speech, the changing contours of free expression. If you've ever doubted the relevance of tonight's lecture, I refer you to a piece in the New York Times just the other day. In fact, it came out on Purim by coincidence. Professors Group says efforts to halt sexual harassment have stifled speech. I spent part of my reading of the Chronicle for Higher Education 2 weeks ago reading a long piece called "Should Campus Leaders Ever Disinvite Controversial Speakers?" occasioned by several recent incidents in which speakers were disinvited because of campus protests about those speakers. It's a topic that's very relevant to us. We have a tradition, Jewish tradition, which takes speech very seriously and has a lot to say about the kinds of speech we should employ. And of course, we all find ourselves in the midst of a political campaign where all sorts of things are being said, which I frankly never thought I'd hear said by presidential candidates for the office of the United States President. We've got a problem here, and we need to address it, and Fred Lawrence is going to help us do that. I have several preliminaries before that, however. First, the ritual. Please, silence your cell phones. If you haven't done so, please do so now. Talking about free speech, silencing speech, this is the occasion to silence some speech. Second, anyone who's here at JTS for the first time, we'd like to give you a warm welcome to JTS and hope that it will not be your last visit. I'm also happy to welcome many, many live stream viewers who are joining us today from synagogues around the country. Welcome all of you to JTS evening's program. We're happy to mention live stream viewers from Beth Hillel Congregation B'nai Emunah in Wilmette, Illinois, Temple Emeth in Chestnut Hill, Massachusetts, Temple Beth Abraham, Nashua, New Hampshire, Temple Israel from Albany, New York, Congregation Agudat Achim from Schenectady, New York, Beth David Synagogue from Greensboro, North Carolina, Adath Israel of Marion Station, Pennsylvania, and the Har Zion Temple of Penn Valley, Pennsylvania, who are holding a joint screening, Congregation Brothers of Israel from Newtown, Pennsylvania, the Rutland Jewish Center from Rutland, Vermont, and all the other groups who are joining us. Welcome to JTS. I want to say a word about this annual lecture in honor of the late Bernard Siegel. A philanthropist and community leader, Mr. Siegel was the first Jewish president of the American Bar Association. He was the first Jewish chancellor of the Philadelphia Bar Association. In addition to his longtime career with the law firm of Schneider, Harrison, Segal, and Lewis, Bernard Siegel carried out special assignments for Presidents Eisenhower, Kennedy, Johnson, and Nixon, and worked tirelessly to extend the influence of the organized bar in matters of legal policy nationwide. Mr. Siegel was recognized for his, quote, indefatigable efforts to expand and improve legal services for the poor, the powerless, and the dispossessed, end quote. He served his alma mater, the University of Pennsylvania, the Jewish Publication Society, the Philadelphia Allied Jewish Appeal, and the Hebrew University, where the law library is named for him. In addition to this evening's annual lecture, his support for JTS, which awarded him an honorary Doctor of Laws degree in 1977, has been recognized through the naming of the Bernard G. Siegel Seminar Room in our Kripke Tower. I'm happy to welcome Mr. Siegel's grandson, Mark Cohen, who's with us here this evening, and acknowledge the presence of Mr. Bruce Rosenfield, a former law partner of Bernard Siegel, and by Bruce's wife, Bonnie Breyer, who's also an attorney, here with us this evening. So welcome to all of you for the Bernard G. Siegel Memorial Lecture. I always say that I have a special debt of gratitude to Bernie Siegel because I went to Central High School, and he went to Central High School, and from the moment I walked in the doors of Central High School, I was made aware of the fact, particularly as a Jew attending Central High School, that Bernie Siegel was one of the most distinguished alumni of Central High School who added to the name and repute of the high school. And now it gives me great pleasure to introduce Fred Lawrence. Frederick M. Lawrence is the senior research scholar at Yale Law School, professor of politics at Brandeis University, and the former president of Brandeis University. An accomplished scholar, teacher, and attorney, He's one of the nation's leading experts on civil rights, free expression, and bias crimes. He's written, lectured, and testified widely on civil rights crimes, and is the author of Punishing Hate, Bias Crimes Under American Law. Prior to coming to Brandeis, Fred Lawrence was the Dean and Robert Kramer Research Professor of Law at George Washington University Law School. His legal career was distinguished by serving as an assistant U.S. attorney for the Southern District of New York, where he became chief of the Civil Rights Unit. Our program tonight will proceed as follows. We'll first hear from Fred Lawrence. I'll then propose one or two questions to Fred, and following that, we'll invite questions from the audience. It's now my privilege to call to the podium Fred Lawrence to deliver tonight's Bernard G. Siegel Memorial Lecture.
Arnie, thank you so much. It's a particular joy to be back at JTS, I get to say. For 10 years, I was privileged to be one of the lay members of the Committee of Jewish Law and Standards. 25 rabbis and 5 lay people in the room debating some of the most significant issues facing the conservative movement and thereby Klal Yisrael. And I will say that it was one of the most exhilarating intellectual moments of my life. As Cass Abelson once said, without the least bit of irony, and I agree with him, and I repeat, without the least bit of irony, one did feel in the middle of those discussions at their most intense that the Shekhinah was in fact present. And it was a privilege to be part of that. So to be back in this wonderful building is a great, great pleasure. It's a particular pleasure as well to be asked to deliver this year's Bernard Siegel Memorial Lecture in Law and Ethics. As Arnie said, Bernie Siegel was a giant of the law. Let me speak personally as once upon a time as a young Jewish lawyer. I'm still a Jewish lawyer, but as a young Jewish lawyer, Bernie Siegel was our Hank Greenberg. And for those of you in the room who don't know what that means, look at one of the people who's laughing, and they'll explain to you who Hank Greenberg was. To have been the first Jewish president of the American Bar Association is more remarkable than most of my students could possibly imagine. Because there was a time when, and not all that terribly long ago, I regret to say, when the American Bar Association, to its shame, was associated with a pretty vicious degree of anti-Semitism. And today, of course, that now feels like ancient history, but it is remarkable that Bernie was able to play that role. And even more impressive that he could become Chancellor of the Philadelphia Bar. Now that's really something. He also was particularly associated with merit selection of judges, a cause that was important then, and I dare say is more important today. And I feel his voice and his wisdom channeling through all of us, and I hope that we are always able to say that he began a practice of merit selection of judges that continues on to this day and on into the future. He belongs on that very short list, in my view, of personal heroes in the law, a short list in which I would include the likes of my hero, Louis Brandeis, and in this building I would add the great Gershon Kext, with whom I was privileged to spend time yesterday afternoon. And I know that Gershon is very much here with me as I'm speaking tonight. In exploring the perilous edge between free speech and hate speech, I would like to begin with first an exploration of the boundaries of free speech, especially in the troubling context of hate speech. I will argue that the boundary should be expansive and that difficult, challenging, and yes, even hateful speech ought to be protected under our system of free expression. This view is largely consonant with accepted First Amendment doctrine. Exploring the development of this doctrine where hate speech and also hate or bias crimes are concerned will demonstrate that the division between hate speech, which is protected, and hate crimes that can be punished cannot, in fact, be drawn along a speech versus conduct distinction. It is tempting to do so, but the distinction will not hold much weight under careful analysis. Instead, the division between that which we should protect and that which we may prohibit, in my view, should be drawn based on the intent of the actor, much as we generally do in the criminal law. When we do so, we will see that certain verbal behavior, you could think of it as a verbal assault, will in fact not fall into the category of protected hate speech, but rather fall into the category of punishable bias crimes. Finally, we will return to the category of hate speech that is in fact protected and ask what the proper response to that speech ought to be. And this will bring us to the most timely topic with which we are all preoccupied today, and that is the relationship between free expression and civility in the public square. In fact, I was half tempted not to bring a text with me tonight, but instead just to bring a copy of the newspaper, pass it out, and we could all read aloud together and discuss whatever's the latest manifestation of our situation. So rather than taking it from the New York Times, let me give you 3 stories to get us started. They take place in 3 different continents in 3 different decades, and they set the context in many ways for me. The first story takes place in December of 1996 at a conference on violence-conducive speech that was convened at Hebrew University at the Center for Human Rights. The conference took place roughly a year after the first yahrzeit of Prime Minister Rabin. And our topic was not speech that literally advocated violence, because all concerned would agree that that could be restricted, but speech that was conducive to violence. And the particular context was the speech around the assassination of the Prime Minister. Many of you will recall that there was much violence-conducive speech at that time, particularly labeling him as a rodef, literally a pursuer. But in Masechet Sanhedrin, we read that the rodef is someone who is pursuing another to do violence, and we are allowed to use force in response, either to defend ourselves or to defend another. Think of it as a kind of halakhic version of self-defense or defense of others doctrine. But of course, that language used of Rabin being a rodef for his own policies created a violence-conducive atmosphere. What was remarkable about that conference, the speakers were Americans, Israelis, British, and Germans. And perhaps not surprisingly, it was the Israelis and the Germans who agreed the most, the 2 legal systems that have grown up in the shadow of the Shoah. And it was we Americans, and to a certain extent the British, who were the most speech protective. I suppose the only one to the more speech protective side of me was the late, great Anthony Lewis, who spoke at that conference as well. At the end of the conference, or the end of our opening session, a German colleague said to me, you know, if there were brown shirts occupying Fifth Avenue during the 30s, you might have a different jurisprudence of free expression. The second story takes place in 2001 at University College London, where I was a visiting fellow at the time. I was giving a paper on hate speech and bias crimes with some of the analysis actually we'll talk about tonight. And one of the British members of the faculty, colleague of mine at the time, in the kind of charcoal gray suit that only those guys can get away with wearing, poses the following hypothetical in an accent I will not attempt to imitate. He said, suppose that a group of skinheads got a truck, painted it up with racist slogans, and drove it right into the heart of Brixton, a community that's overwhelmingly Caribbean and African. Could that be prohibited? And I began to explain how I would think about that, actually along the lines that I will discuss momentarily in my analysis tonight, in terms of looking at the intent of the actor. And he listens for a few minutes and he says, why is this so hard for you? We all know it's wrong. Why is this so hard for you? The final story takes place most recently, December of 2014, and as it turns out, it's also the most proximate, just a few hundred miles from here, Waltham, Massachusetts, the Brandeis campus, during the time I was president. It occurred right after the murder of 2 police officers here in New York, in revenge, as it were, for the death of Eric Garner and Michael Brown. A member of the student body, African-American member of the student body who was very involved in the Black Lives Matters movement, tweeted to her 60 or so followers that she had no sympathy with the police officers. Now, knowing this student, I believe what she meant was that she was deeply frustrated and troubled that in her view, vastly more attention had been paid to the deaths of officers Wenji and Liu and Rafael Ramos in the broader community than had been given to the deaths of Garner and Brown. But alas, that is not what she said. What she said was she had no sympathy for the death of these two officers. And with help, if that is in fact the right word, it was intended to drip with irony, with the help from one of her 60 or so followers who received the tweet and posted it on what can best be described as a heresy-chasing website, her tweet went viral. As you would imagine, I received enormous pressure from all sides on this set of events. Some urged that the student be thrown out of school or at the very least lose her financial aid package. Others argued that I should issue a short statement supporting free speech and the right of all members of the community to say whatever it is they wish. I will return to this case at the end of my remarks tonight. At the very least, that ought to keep you around. Of us who have experienced a group of which we are a member that is subjected to a bias crime knows the feeling of an individual attack to us as non-participants, as members of the target community. Moreover, a bias crime causes a more profound injury to the general community, exciting an extraordinary level of public condemnation and arousing passions that exceed the reactions to other forms of even large-scale violence or human tragedy. Think of it this way. If I were to describe Kristallnacht as a large-scale act of state-organized arson, I would not have described the crime even remotely. Taking out the anti-Semitic nature of the crime misdescribes the crime altogether. But the feared demise of the Bias Crime Project after RAV was premature. The following year, the Supreme Court took up the issue again in the case of Wisconsin against Mitchell, a case I was privileged to be involved in. And I must say it was not a completely selfless exercise. You see, to speak personally for a moment, I will tell you that RAV in Wisconsin against Mitchell came up in 2 years and 1 year before I got tenure. And it would have been a heck of a thing to have your entire scholarly project struck down as unconstitutional. So I did have a dog in this particular race. Under the Wisconsin law, Gregory Riddick, a 14-year-old young man who had been convicted of an aggravated battery in the severe beating of Todd Mitchell had been convicted of beating Gregory Riddick, in this case, a black man beating a white man up, but with racial motivation. He was sentenced to a higher level under the Wisconsin bias crime statute. The Supreme Court in Wisconsin and Mitchell upheld the Wisconsin bias crime statute, employing a speech conduct distinction. Chief Justice Rehnquist, for a unanimous court, said that whereas the ordinance struck down in RAV, the cross-burning, was explicitly directed at expression, that is to say speech or messages, the statute in Wisconsin was aimed at conduct, which, as he said, is unprotected by the First Amendment. Well, for those of us engaged in the Bias Crime Project, we were delighted with the result in Wisconsin against Mitchell. The result, yes, but the reasoning, no. It is, as I said earlier, tempting to distinguish punishable bias crimes from protected hate speech by describing bias crimes as conduct and hate speech as expressive. Despite substantial scholarly criticism, this speech conduct distinction, I have to say, has had remarkable sticking quality in court's analysis. It's tempting to use the distinction because it promises a predictable and logical way to draw lines. Once we can differentiate speech from conduct, we can effectively protect the former, and we can punish the latter. The promise, however, is ephemeral because the speech-conduct distinction simply doesn't work. It is, in fact, far too brittle. Speech and action are not merely intermingled, they are inextricable. Thus, the dialectic encompassing speech and conduct precludes not only a neat separation of the two, but even efforts to determine which one is the predominant element. If you think of, for example, holding a sign up at a rally, is that speech or is that conduct? If you think about burning a flag, as I said earlier, speech or conduct? Or in a case that's evocative of an earlier error, United States against O'Brien, O'Brien was prosecuted for burning his draft card. Speech or conduct? Well, the great theorist John Hart Ely had a wonderful description for all of these when he said, burning a draft card to express opposition to the draft is an undifferentiated whole, 100% action and 100% expression. It involves no conduct that is not at the same time communication, and no communication that does not result from conduct. The point here is that when we try to rely on a speech-conduct distinction, we inherently have put the rabbit into the hat to begin with. If it's something we wish to protect, we will say it was expression, and therefore we wish to protect it. And if it is something we wish to punish, then we will say we found it was conduct, and that was our right to punish it. Perfectly helpful and perfectly circular. So the critical decision, which behavior may be punished and which should be protected, to me is wholly extrinsic to the process of trying to categorize speech and conduct. If a meaningful distinction between bias crimes and hate speech exists, we must find it elsewhere. My proposed distinction finds its roots in criminal law doctrine. Now, as every first-year law student knows, and there's at least one of my own first-year law students sitting somewhere in the room, but I shall not call on her again, because if I did, the color would drain out of her face, wouldn't it, Candace, wherever you're sitting? I remember giving a Devar Torah at our congregation in Boston, and one of my students heard it. I actually did it in a dialogical discussion way, and came up to me afterwards and said, you know, I really saw the connection between how you teach in synagogue and how you teach in class. He said, this was like the Socratic method, except no one got hurt. I think he was kidding, but to this day, I'm not sure. Was he kidding? No, he probably wasn't kidding. As any student of criminal law knows, there are two elements of a crime, the act element and the intent element, or to use the law Latin, the actus reus and the mens rea, the intent requirement. It is the mens rea that distinguishes between and among purposeful conduct, reckless conduct, negligent conduct, and even reasonable conduct. When I've done a lecture just on this piece, I'll do a very truncated version of the hypothetical here, but it goes something like this. If I tell you that someone takes a bat and hits someone else in the head very hard, causing a huge welt in that person's head, in fact, the person loses consciousness briefly, may even have a concussion as a result of it, what crime has been committed? And then you take hands in the room and people will say assault, assault with a deadly weapon, intent to kill, attempted murder, whatnot. And then there's finally one smart person in the room who says, I need to know another fact. And of course, what's the missing fact? What's the intent of the actor? Because now I shall add another fact. The person with the bat was standing like this. And the person who got hit was standing like this. And in fact, what happened was the bat went back too hard, too fast, and the catcher was standing too close and got hit in the head. Same welt, same concussion, same physical injury. But we have gone from attempted murder or assault with a deadly weapon down to no crime whatsoever. And it's not just the culpability of the actor. The actual harm to the victim is different. Oliver Wendell Holmes famously said, even a dog knows the difference between being tripped over and being kicked. And to be purposely assaulted as opposed to negligently assaulted as opposed to accidentally assaulted are entirely different crimes. If we look at the actor's intent, we find, I believe, a more helpful way of distinguishing that which ought to be protected and that which might be punished. Consider first the perpetrator of a bias crime such as the racially motivated assault in Wisconsin and Mitchell. Todd Mitchell possessed the mens rea for the crime of assault with a specific intent to cause harm to the victim. Now consider the speaker of hate speech. He lacks the mens rea for any crime. His intent is strictly one of expressing himself. This is not to suggest that the speaker's act of expressing himself is purely what the philosophers would call deontological or without concern for its conduct or its consequences. To the contrary, all expressions have ramifications another great Oliver Wendell Holmes insight. He said, every idea is an incitement. The speaker of hate speech, however, does not seek to cause injury to a particular victim, and thus lacks the mens rea associated with the crime of assault. This distinction, then, is keyed to the mental state of the actor, and it does not resurrect the overly simplistic speech-conduct distinction. The perpetrator, if that's even the right word, of hate speech lacks the criminal intent to harm, whether his speech takes the form of thinking, talking, flying a flag, or painting a sign. His behavior, which we, along with Professor John Hart Ely, may assume is 100% action and 100% expression, does not constitute a crime. If it did, as we will come to cases of momentarily, our answer would be quite different. Two examples drawn from another cross-burning case before the Supreme Court, Virginia against Black, in the early part of this century, help make the point. In Black, the Supreme Court struck down the Virginia cross-burning statute. A majority of the court would have upheld the first part of the statute, which made it a crime for anyone with the intent of intimidating any person or group of persons to burn or cause to be burned a cross on the property of another, a highway, or any public place. It's worth noting that in saying that this part would have been upheld, the court had in fact already traveled quite a distance from the RAV decision, where the court struck down the St. Paul cross-burning ordinance. Writing for the majority, Justice Sandra Day O'Connor said the First Amendment permits Virginia to outlaw cross-burnings done with the intent to intimidate, because burning a cross is a particularly virulent form of intimidation. But the court struck down the law because of what came next. What came next in the statute was, any such burning of a cross shall be prima facie evidence, shall all things being equal be taken to prove, shall be prima facie evidence of an intent to intimidate a person or group of persons. But in fact, not every cross burning is intended to intimidate a victim. And the two cases before the court in Virginia against Black make the point. Like textbook examples, the two cases represented the two poles of cross burning: domestic terrorism on the one hand, and expression of white supremacy on the other. In one case, Barry Black led a Ku Klux Klan rally on private property, at the conclusion of which a 25 to 30-foot cross was burned. In the other case, Richard Elliott and Jonathan O'Mara were prosecuted for attempting to burn a cross on the lawn of an African American, James Jubilee, who had recently moved next door. Elliott and O'Mara were trying to get back at Jubilee because, among other things, Jubilee had had the temerity to complain that Elliott and O'Mara were using their backyard as a firing range. The prima facie evidence clause of the cross-burning statute impermissibly blurred the lines between these two different meanings of cross-burning. As described by Justice David Souter in his separate opinion in the case, its primary effect is to skew jury deliberations towards conviction in cases where the evidence of intent to intimidate is relatively weak and arguably consistent with a solely ideological reason for the burning. To be constitutional, therefore, the statute would have to require proof of an intent to intimidate. Proof that a cross had been burned itself would be insufficient. So we may now apply a similar analysis to cases of pure hate speech. Words alone can, in fact, sometimes constitute a crime. Behavior designed to instill serious fear certainly may be criminalized. And it does not matter whether it takes the form of spoken words alone, physical conduct alone, or some combination of the two. Many states have some form of assault laws that prescribe the creation of fear or terror in a victim. They are variously called menacing, intimidation, or threatening statutes, and they may be violated through a defendant's use of words alone. Reviewing courts have upheld various forms of verbal assault statutes if sufficiently narrow in their focus. Intimidation statutes, for example, which criminalize words used to coerce others through fear of serious harm, are constitutional so long as it is clear that they apply only when the words are purposely or knowingly used by the accused to produce a fear and that threat is real. Menacing statutes differ from intimidation statutes in the sense that whereas intimidation statutes focus on coercion, menacing statutes focus on the specific intent to create fear. But in the same way, it is a targeted act, sometimes through the use of words alone, to instill and create fear. So in some cases, hate speech will in fact cross the line from protected expression to punishable hate crime. It does not matter whether the speech takes the form of a racial epithet or the burning of a cross on one's property. Either way, the actor's behavior is a crime only when the purpose is to put his victim in a state of imminent, serious fear of harm. When he does so with biased motivation, then we would say that behavior has become a hate crime. Thus, the epithet, when screamed at the victim in a menacing manner, or the cross when burned on the lawn of the black family to terrorize them, is no longer merely hate speech. It has become a hate crime. Now, having demonstrated, I think, that most, but not all, hateful verbal activity is protected as free expression, depending on the mental state of the actor, let me now turn to the final and in some ways to me most significant question for our time. What ought we to do in the face of hateful speech that is in fact constitutionally protected? Here I am mindful of a brilliant essay that the art critic Robert Hughes wrote some years ago, back in the 1990s, after the attempt to censor the Robert Mapplethorpe exhibition at the University of Cincinnati Museum of Art. Some of you will remember the Mapplethorpe exhibition that the city of Cincinnati decided was obscene and they wanted to shut it down. Hughes observed that, and maybe it takes a non-lawyer to ask the right questions that lawyers stopped asking, and maybe it takes a non-American to ask that "why is this so hard for you" question that Americans forget to ask. Hughes said, we tend to over-constitutionalize our most important questions, as if the only interesting and important question to ask was whether or not Mapplethorpe's art was constitutionally protected. It is, he said, the court said, and I think they're both right. But that's not the ultimate question, Hughes said. That's only the threshold question. The ultimate question is an aesthetic question. Is any of Mapplethorpe's art any good? And he went on to write an essay in which he critiqued some of it, saying some of it was quite good, some of it less so, and some of it was just plain lousy. But if we focus on the constitutional question alone, we preclude ourselves from the ability to have that discussion. I believe something similar happens in the context of hate speech. Just as there must be room for aesthetic questions as to the merits of constitutionally protected art, there must be a context for a moral response to constitutionally protected hate speech. The moral response to hate speech is to describe it as such and to criticize it directly. Louis Brandeis was right, after all, in his celebrated opinion in Whitney against California, that the answer to bad speech is more speech and not enforced silence. This allows us to return to the third story that I promised you I would come back to. Recall the student tweet of no sympathy with the murdered New York City police officers a little over a year ago. Strictly speaking, this is not a matter of hate speech, but bear with me, and I will give you a case momentarily, one last example, which is precisely an example of hate speech. In the instance that I told you about in that story, I had, as I described to you, free advice from both sides. Both said quite vociferously and compellingly. And I rejected them both. I rejected the idea of expelling the student from the university or pursuing any disciplinary actions against a student, such as terminating her financial aid package, that would be to engage in what Louis Brandeis called enforced silence. I believed her tweet to be protected speech. But I also believed that this was a case that called for more than a mere statement confirming her right to speak. In the same statement that defended her freedom of expression and her academic freedom, I added a criticism of my own, saying that in my views, her comments were contrary to the highest values of the university, and that I found them to be abhorrent. Consider now the case that occurred not long ago at the University of Oklahoma. In fact, just over a year ago, last March. Some of you may recall this case. Members of the Sigma Alpha Epsilon fraternity, on their way to Fraternity Founders Day, engaged in a horrific racist chanting that included the use of the N-word as well as a celebration of violence and lynching. 2 student leaders of the fraternity were expelled from the university. I am highly sympathetic to the impulse for this expulsion, and I share in full the university president's statement that he was sickened by the event. But I question the case for expulsion. Had the context been different, that is, had this occurred outside a predominantly African-American fraternity house, one can imagine how this indeed would have been a case of verbal assault, warranting full punishment. As it was, with the actors instead singing on a chartered bus in the presence solely of their own members, this to me was an instance of protected hate speech. Vulgar, disgraceful, and yes, sickening, but also protected. There was no intent to threaten or cause harm to anyone. I believe the well-intended impulse to punish the leaders stemmed in large part from a correct sense that this behavior required the strongest possible condemnation, but an incorrect assessment of the possible responses. We bind ourselves to an impoverished choice set if we believe that we either punish speech or else we validate it. There is a middle position, Brandeis's dictum of more speech, that allows us to respond without punishing. In the face of hate speech, the call for more speech is not merely an option, it is a moral obligation. When I criticized the student tweet, and on one similar occasion, when I protected but criticized a faculty listserv that included vulgar and disgusting language aimed at, among others, my predecessor and the State of Israel, I was accused by some of creating a chilling effect on their right and ability to express themselves. So let me conclude tonight with my response to that charge. Not all chilling effects are bad. There are those that are cases of enforced silence, of which Justice Brandeis spoke. This is classically what we mean by a chilling effect. These are pernicious, and they are contrary to our system of free expression. But then there are those that are cases in which we influence each other for the good, when we are touched, as Abraham Lincoln said in his first inaugural address, by the better angels of our nature. We do indeed seek to have an effect on each other, chilling or otherwise. Jeremy Waldron asks what the role of hate speech will be in John Rawls' well-ordered society. In Rawls' work, Political Liberalism, and also somewhat in the Theory of Justice, he describes the well-ordered society as a thought experiment of a society in which all respect the rights of others. A well-ordered society will definitely not look racist, Waldron said, but this will not be because there are laws against that sort of thing. It will be because the citizens, being citizens of a well-ordered society, have no wish or motivation to express themselves in those terms. Thus, a well-ordered society would have no legal prohibitions on hate speech because there would be no impulse to do that which they forbid. Now, Waldron thinks that this argument is misconceived because there will always be an expressive role for the laws as well as a disciplinary one. But I would argue that this expressive role need not be played by legally enforceable obligations alone, especially criminal laws, but perhaps not even civil sanctions. Each of us has an obligation to speak in response to hate speech. The only chill that this creates, if chill is indeed the right word, is one that brings us closer to a society in which the dignity of all is not only protected by the state, but is cherished by each other. Thank you.
My expression is wow. You're just treated to a really sophisticated and careful address. To review the format, I'm going to ask Fred a couple questions, and then in a few minutes we're going to ask people to line up here. And if Julia has questions from our live streaming audience, Julia's going to present them to me as well.
Right, the answer to the first question is not this year, but the Knicks will make the playoff next year.
Lack of confidence. All right. So, Fred, let me ask you, take you on a line of argument you didn't really explore. Do these things in our pockets that I asked us to silence at the start, has this changed things in any way? Have you looked into whether this changes the whole nature of law in this, and what has been adjudicated so far in these questions?
Yeah, it's a great question. I think, and these things in our pockets as a surrogate for social media generally.
Exactly, social media generally.
Right.
And the way that social media is being used now in all sorts of ways that clearly cross the line to hate speech and incitement even.
Yeah, and I think the way in which it has changed things, and there has not been much adjudicated on this, but it will come. One of the ways in which it changes things is that the notion of an assault used to require that one be physically proximate to another. Mm-hmm. When we live much of our lives, and this is particularly true of my students' generation, but I think increasingly it's true for many of us, we live much of our lives in virtual space. Mm-hmm. It means that one can be assaulted virtually in a virtual place. Mm-hmm. I think where that now plays a role is that verbal assaults, right? People tend to use verbal to thinking that means that which comes out of your mouth, right? Verbal means of or pertaining to words as opposed to oral or written. So verbal, meaning any kind of word-related assault communicated through the internet, can certainly be prohibited, but again, if it is focused on one person and with the intent, I would go back to the mens rea, to instill fear on a particular victim. I think there is much on the internet that is in fact expression of hateful views, which falls into the category of a Klan rally and therefore would be protected. But where it is different in part is that we can now actually be proximate to another without being physically anywhere near another.
Exactly. So if those Oklahoma players had targeted the email accounts of the black fraternity and made sure that those words which you might even call fighting words, I think, arrived on their internet screens, right? Right. They could be conceived as a threat.
Absolutely. And that's why, asking that question of what is in the mind of the actor, many times, particularly first-year criminal law students will say, well, how do you know what's in the mind of the actor? The answer is sometimes you don't, and that's why we have a presumption of innocence. When you don't, people ought to be acquitted. But sometimes it's actually easier than one thinks. And if, in fact, you had a group of students who had targeted emails specifically of African-American students, let me tell you, as a former assistant U.S. attorney, I'd take that case, because I think we'd have no problem proving beyond a reasonable doubt that there was an intent to intimidate those individuals.
So can I ask you a question that we both know comes up in Talmudic law all the time, and this question of the mind of the actor. Human beings are pretty good at self-deception. And there are things that we should know, that we might say reasonable people should know, that particular actor can claim reasonably that actor did not know. Right? We have this distinction between animals that are tam and animals that are muad, right? And if you have an animal that's harmed people in the past, you may have all the innocence in the world about sending that animal out to pasture, but no matter if that animal has a record of doing damage to other people's fields or other people's livestock, your intention in putting that animal out to pasture doesn't count because that animal has a record, right? And you're responsible for what that animal does because you should have known better. So what about people who should know better? They may think that, well, I don't have any intent to harm. I'm just venting. I'm just letting off steam. But they should know that these kinds of words do damage. That these kinds of words have been accompanied by violence in the past. What about that?
Well,
case?
Typically we don't punish people for being stupid, and if we did, the jails would be pretty crowded. And I don't say that to be glib. It's a hard question, but what it means is not every problem was designed to be solved by the criminal justice system. We know what societies are like that solve every problem through the criminal justice system. That is the model of an authoritarian society. Right? Ours is a society that is designed to address problems in many other ways. And when people do behave in inappropriate ways, there should be social opprobrium, there should be moral opprobrium that directed at them, and that should influence their character. But that does not mean that they ought to necessarily be punished. Even in the case that you give, there's a difference between that which you know and that's what you should know. And if you have actual knowledge of the animal, it's an entirely different situation. So we know that the intent can trigger many obligations. Something as simple as saying this is what you're going to set aside for Bikurim all of a sudden changes the nature of the goods, right?
So can I just maybe
He didn't know that I knew that, by the way.
I did know that you knew that. I assumed that you knew that. But can I press you on one thing? So the reason why we're bending over backwards, as that man in Britain said, like to defend free speech, is because we're making an assumption based on history that the consequences of the opposite are too disastrous for our society, that they're going to lead us in an authoritarian direction, and therefore there's a slippery slope there, right? And even at the price of injury to personal dignity and even threat to personal safety, we're willing to go this extra mile, whereas the German society and the Israelis might not be willing to do it to the same extent.
Yeah, I think that's part of it, but I think there's another side of the free speech argument. I mean, a separate version of this lecture, I gave you about one paragraph on why I thought hate speech was constitutionally protected. That could be a full lecture all in and of itself. But the examples that I chose for you are in fact not, that is to say, Bob Post, Ed Baker, I also would look to Louis Brandeis' work on this, is in fact not consequentialist argument. Many of the justifications of free speech are consequentialist arguments that say you protect speech because of the results that you will get. That's Oliver Wendell Holmes' marketplace of ideas. You'll get a better result from that. As opposed to what Brandeis says, which is a much more continental philosophy view that says who we are as human beings is how we get to express ourselves. What distinguishes us from the animals right besides our thumbs is the fact that we are expressive beings, that we can use verbal means of communicating with one another. And that when the state shuts that off, that is something that is enormously impactful on the autonomy of the individual and on the dignity of the individual.
Right. All right, I think we'll throw the floor open to questions from the audience now. Julie, do you have one from the live stream audience before we get to the live people in the room here?
Yes, I'm pleased to share a question from our live stream audience. I think it's actually, I received a handful of questions from our live stream viewers. They all relate to the campus setting, which I think is noteworthy.
Please.
Right.
I'm going to share one from an undergraduate at Brown University, Benjamin Gladstone. I chose this one because it's the most different from what you spoke about already. Many students on campuses today make the argument that free speech, as it's traditionally conceived, is in fact not free because it privileges perspectives of actors that have the money, connections, and other resources to position themselves as authoritative and to amplify their own voices. Could it be that unregulated speech, in fact, leads to such an uneven playing field that some speech is naturally suppressed by others, so that the freest system of speech would in fact be a regulated one?
Yeah, it's a great question, and actually the questioner has put the argument very well. That is an argument that is often brought, and I think has coherence to it. It happens to be one I reject for reasons I'll come to in a moment, but it does have a strong coherence to it that says that free speech, in fact, is premised on the idea that everyone is an equal participant in the community, which everyone is not. I think the idea of regulating speech to get to a better playing field is a cure that is worse than the disease. I understand why it is tempting to do that, but ultimately I believe we are better served by really pressing on making sure that the discussion is a free, open, and fair discussion. And I think if that exists any place, it ought to exist on university campuses. And where it doesn't, it is incumbent upon, presidents and chancellors to step in and see that it does. In this regard, you'll notice that one of us is a former president, so it's easier to be a big shot about these things. No, but this is the reason I gave examples from my own experience. These are not easy questions, I understand that, and these are real situations where real people are being affected. I think what is important to understand, in my view, is that the price of membership in a free society and the price of membership in an academic community is sometimes having your feelings hurt. It is having your views challenged. It is having your deepest convictions challenged. But no one is allowed to threaten anyone. No one is allowed to put anyone in a position of fear. It is not always easy to call the balls and strikes on that particular line, but that's what, within a university campus, presidents and chancellors and deans are called upon to regulate.
I can remember times in classes when I first started teaching that women, for example, would not speak up with the same frequency that men would speak up. And so as a teacher, one had to make special room in that classroom for the voices of women. Is this questioner not making an analogous point?
Well, I think that's right, and I think that's part of broadening the discussion, but allowing, going back to Brandeis, more speech rather than enforced silence. I think the idea of making sure that more people are able to speak, creating more fora for more people to speak, making clear what's available as different ways of speaking, that certainly is appropriate. Opening the doors wide, but not prohibiting any of it.
Sir.
I wouldn't have such a great question as this lady, but I'm getting down to earth a little bit more with a very basic question. If somebody calls you a Jew, either in public or in private, is it a free speech or a hate speech?
Well, I'll tell you, I'm with your question, I'm back at University College London, and I'm being asked the same question, and I'll give the same answer. I need to know what the person is doing, because there are going to be times when there are going to be times when it's a compliment, and there are going to be times when it's a threat. And it's going to be hard to know sometimes, but it's going to be surprisingly easy to know others. Look, I will tell you, I spent 5 years as an assistant U.S. attorney. As the Chancellor said, I was the chief of the Civil Rights Unit. These are some of the cases that we brought. The FBI had detailed guidelines on how to prove racial motivation, religious motivation. Sometimes it's hard, but when you've got a swastika on a synagogue, it's pretty hard for the defense to say our motivation was something other than religiously motivated violence.
And the second question was, what's the answer to the repeated attempts of Alan Dershowitz or Daniel Pipes of trying to speak on campuses and not being allowed?
Yeah, I think this is a powerful question. Everyone has the right to be heard. No one has the right to disrupt. There's no constitutional right to disrupt. This is another challenge that we all have. And the best way to test your instincts on this is, do you feel that way when the speaker is somebody you completely disagree with? So I'll go right into the heart of it, and no, I won't talk about Donald Trump, as tempting as it is, but I won't. Right? Tom was wondering, was I going to get to Trump? But he had 837 in the pool for the first time Trump came up, and he thought he'd won. No, I'm going to talk about actually Shockley, who some of you will remember for his racist theories. When he spoke at Yale, he was booed down so vociferously that he finally had to give up, and he turned around on the blackboard and he wrote "Pity for Yale" and walked off the stage. The students who silenced him, who booed him so that he couldn't speak, gave him the only victory he could have won. Because on the right to be heard, he was right. On everything else, he was wrong. So they should have let him be heard. My rule as a university president was that everyone had a right to speak. Anyone could invite a speaker to campus. The ground rules were you had to be willing to answer questions. You couldn't come and give a speech and then split. And I can tell you, when we had certain speakers, I could even predict which trustees were going to call and say, how can a school like Brandeis permit so-and-so to speak on campus? And I'd say, have a little faith in my kids. There's going to be a Q&A period, and I can tell you, they're going to slice them and dice them, and it will be much more effective than if I hand them the only victory you get and keep them from coming to campus.
Yes.
Hello, I'm Justin Pfizer. I'm a freshman at Liss College, the undergraduate program at JTS and Columbia. So AMCHA, which is a group that monitors anti-Semitism on campus, recently found that anti-Zionist groups often induce anti-Semitic actions, and given that I find there are moral ambiguities with the BDS movements, would you charge institutions like JTS to take positions and stances against the BDS movement and Israel Apartheid Week, which I found were lacking?
You know, I would say that I think the recent statement of the University of California got it roughly right. And here I'll digress for a second and quote the great Marty Oppenheimer, Nobel Prize-winning economist, who said, I would prefer to be vaguely right than precisely wrong. And I think that the argument that was put to the University of California, for those of you who haven't seen the statement, was that there should be a condemnation of anti-Semitism, which they did, and that they should condemn anti-Zionism as anti-Semitism, which they did not do. They said instead that they condemned anti-Semitism and anti-Semitic forms of anti-Zionism. I think that got it roughly right, because I think there are forms of anti-Zionism that I think are wrong on the merits, and I've got my right to complain about them and to argue about them, but I would not per se label them as anti-Semitism. And I think even the BDS movement, with which I have great, profound differences, but even the BDS movement has within its borders people who are anti-Semitic and people who are deeply opposed to the notion of Jewish nationalism. One can be opposed to Jewish nationalism without being an anti-Semite, though goodness knows there are plenty of anti-Zionists who are anti-Semites.
Thanks.
My name's Isaac Binkovitz. I'm an attorney here in New York at Allen & Overy.
Speak into the mic, please. We have
sorry.
the live stream on.
My name's Isaac Binkovitz. I'm an attorney here in New York at Allen & Overy. I'd like to ask you about what the responsibility of social media is in terms of what's Facebook's responsibility when people are posting hateful content, and also when people are posting terrorist propaganda and other types of extreme hateful content that's increasingly common.
Yeah, I think this is a deceptively complicated question, because if the government were in the business of policing Facebook or policing other platforms, I would be much more queasy about saying, who's regulating speech. Again, let's just quickly put to one side, what I have described as verbal assaults, that which clearly crosses the line, where I have no problem with the government regulating it. But if it's protected speech, I am concerned about the government prohibiting it. But the same way that I made statements, I would expect those platforms to make statements in certain instances and say what the rules of engagement are and what goes and what doesn't go. The only thing I would urge is that we err on the side of more speech, not less speech. It is sorely tempting to silence that with which we disagree and that which we find deeply offensive. At the end of the day, that it's a dangerous path to start down. But I do think that there has been some more sensitivity in the social media space to policing the level of civility in discussion and saying what the ground rules are. And as far as that goes, to use that description, the doctrine that I alluded to in my talk, as long as it's content neutral, then I think it's appropriate. You wouldn't want a social media platform saying that people who are particularly vociferous from a conservative perspective can be silenced and liberal ones not, or vice versa. But to say certain kinds of speech doesn't go here within their platform, that's their business, as long as the government is not playing the role of silencing anyone.
Marty?
I'm Marty Oppenheimer. I'm actually general counsel here at JTS.
And a member of the Yale Law School class of 1980.
Go Yale Law School 80. So let me ask you to elaborate. When you were president of Brandeis, you revoked the invitation of a woman who was going to speak and was very critical of Islam. How do you square that with the doctrine that you've given us about more speech is better?
Sure. Well, first of all, she wasn't going to speak. She was going to get an honorary degree. She wasn't going to speak. I know there's been much written about that, including by her, but she, in fact, was not the graduation speaker. Jeffrey Canada was the graduation speaker, and in fact, I'd set him up 2 years in advance because sometimes, as Arnie knows, these things take a long time. I had Jeff Canada, who some of you know from the Harlan Children's Zone, remarkable man, set up, and then something came up. He couldn't speak the year before, and I said to him, okay, but you got to give me next year. He said, okay. So Jeff Canada was set up 2 years in advance. There is a difference between that which we honor and letting somebody speak. And to me, it fits directly, precisely into the distinction that I've made. I was not going to honor someone who is associated with comments that say that all Islam should be destroyed. And when she was asked, you don't mean all Islam, you mean radical Islam, she said, no, all Islam must be crushed and something new built on its foundation. If anyone had said that about Judaism or Christianity and I had sought to give that person an honorary degree, there would have been an uproar and they would have been right. In terms of speech, she was not only permitted to speak on campus, I issued a personal private invitation to her and a personal public invitation that still stands. I guess I can't make that invitation anymore, but I have every reason to believe my successors would agree with that. But right up until near the end of my presidency, reached out inviting her to come speak on campus. So this had nothing to do with speech. This had to do with honoring, and that's something entirely different.
Hi, Fred. Neil Rothfeld.
And a member of the West Side Minion back when we were all younger.
My first question was on University of California. That's been taken, so I'll go to my second backup. Something that's really bothered me for 40 years. None of us should be comfortable when a group like the neo-Nazis marching in Skokie, Illinois, as they did back in the mid-'70s. But the prevailing opinion was, yes, they have a right to speak. I do agree with your notion that they should be met with counter demonstrations, more speech. It's still not enough, and it still has always made me uncomfortable that while they might have a right, something else has to be done. I think the group Southern Poverty Law Center has taken a different approach over the years, and that has really tried to put these groups out of business. Through the courts, they win some, lose some, but the idea is to make them, through mounting legal bills and whatever it takes, but through their persistent opposition, to try to bankrupt some of these. And one of the notorious groups that they went after was the Aryan Nations out in Idaho, and I think they had significant success against them. And so I think there's, sometimes the courts can only do so much, and sometimes we have to do our best to not support, while they might have a right, they shouldn't have free legal defense as, this isn't like an anti-civil liberties union rant, but I did take issue with them for running to their defense. Let them go out, get a private lawyer, let all the hate groups go out, have to pay their own legal bills, and go out of business doing so.
You know the way the Skokie case actually ends, people forget this. I mean, after the Supreme Court, the final appeal, upheld the right of the neo-Nazis to march, they did march, and they were revealed to be this pathetic little group. And they were vastly outnumbered by the counter-demonstration. It seems to me, and I'm not being flip, I completely understand the depth of the reaction of the citizens of Skokie, and particularly the survivors of the Shoah who lived, and their families who lived in Skokie. I understand the depth of the response. That said, Skokie made a strategic mistake, in my view, by denying them permission to march, because just as I said earlier about Shockley, they handed the Nazis the only victory they could win. If they had to present their own views, they would fail. And I think even now, with the vulgarization of political dialogue in this country of a level that we have never seen, certainly in my lifetime, even now, there are moments that should not be taken cheaply. And that is to say that the association of Mr. Trump with David Duke was like putting your hand on a stove, right? And he did get burned for that. Now, what is that going to result to in the election? That's not what I'm here to talk about tonight, right? We all have our own politics on this. But I think the reaction that there was something horrific in not denying a Nazi, a KKK connection, and that was a position, that was a condemnation that went left to right, right? That went right across the board. People condemned that. That shouldn't be taken lightly. So I think when you maintain that kind of opprobrium, you're actually doing the right thing. Having said that, the Southern Poverty Law Center has been very effective in putting some of these guys out of business, and I got no problem with that, as long as you got some actual business that you're suing them for. If all they're doing is giving their speeches and handing out their leaflets, then you wouldn't be able to sue them for much of anything.
Time for two more brief questions. Ma'am.
I'm Letty Cotton Pogrebin. I'm a writer.
Tell them where you went to school, Letty.
I went class of 59,
Proud Brandesian, absolutely.
Yeah, very, very proud Brandesian. Some of the most wonderful years of my life, formative years. My question is informed perhaps partly by the fact that I'm married to a labor relations attorney, and I therefore know he talks a lot about hostile work environment.
Mm-hmm.
And I've asked him at times to define hostile work environment, and it's something like a pornographic calendar on the inside of a locker that's left open in the workplace that's seen by women. I'm interested in how you define an analog to the hostile work environment in campus terms, and also to factor in Arnie's comment about the fact that women are less likely perhaps to participate in public conversation just from our socialization, from the atmosphere. Witness the fact that I'm the only woman who has stood up here. There's something about JTS that does not necessarily, at least in this space, inspire women. I'm sure there are women who have a lot of questions. I don't know why women don't get up, but that in itself tells me that we need to make a much more friendly environment for women, and that in fact anything intimidating that is not intended to a specific person nonetheless has an impact on women's comfort in expressing themselves.
Yeah, I think that's right, and I think there are many things that are harmful to which that you're giving me a moving target. It's okay. Okay, there are many things that are harmful that require a societal response short of prohibition or the criminal justice system, where you would expect such some kind of a response. Hostile workplace environment is a good example of not criminal but civil rules that require conduct that allows people to be able to do their jobs within a particular environment. Now, you wouldn't expect those same rules to be true in the public square, but within a particular workplace, you can say, this is the right of all workers within this workplace to have the ability to function. That brings us into the classroom. That's why there's certain kinds of behavior and conduct in the classroom where we can prohibit things that you wouldn't want the government to do, that you wouldn't want to happen in the public square, and where we can play a particular role of trying to encourage other people to be involved. That's true, excuse me, that's true in discussions in class. That's true in terms of how you run your class. I mean, I certainly observed as a law professor for years that men were much more inclined, to volunteer when they had no business volunteering, and women were much more inclined to begin with, I'm not sure this is right, but. And I remember one particular student of mine who I'm proud to say, she was a research assistant of mine, and I'm proud to say is a very successful practicing lawyer in New York today in her own firm. She got tired of a big firm, she went out on her own. But she was very much in this, with a very sweet smile, she'd say, I'm not sure this is right. And she came to office hours one time, and I was afraid I was overstepping, but I said, you got a great future, but you got to lose that verbal tick. You got to lose that verbal tick of undercutting yourself and saying, I'm not sure I'm right. I said, you're sure you're right, or you wouldn't be saying this. So give it a shot. I said, there are plenty of guys in the class who should be saying, I'm not sure I'm right. And they're not. But that's my role as an academic in my classroom. And I would be loath to let the mayor or the governor or the president play that role in the public square.
I will sneak in one final question.
Yeah, sure. First, I'd like to make a comment. I love your optimism about the Knicks, but it's good that you're
Misplaced,
next
right?
year?
Misplaced. Next
For
year.
Zingis, I'm telling you, next year we're going to be there.
Oh, okay. And my question is...
Not that I think about these things too
no,
much.
No. My question has to do with kind of the responsibility legally from a couple of your examples, right? So you had those kids on the bus doing what they did, and let's say somebody on that bus then killed somebody, right? Or the girl at your school who maybe it was a little bit more, it wasn't such, I have no sympathy, but this needs to happen more, so we're heard more or something, right? And then somebody,
Right.
what does the law say about that?
Yeah, there is a line that neither of those cases is near, but there is a line of direct incitement. Right? And at some point you do cross a line, and you would, in my view, want it to be pretty far out there before you start punishing it. But I'm only being partly tongue-in-cheek when I say the let's get him speech. That's not protected speech, right? That's conspiring, or that's aiding and abetting criminal activity. But it would have to be pretty far up the line towards both intent and conduct. So again, tell me what's going on that bus. And if that bus is going into a certain neighborhood, or if that bus is aimed at a certain place, I could imagine the facts being changed in such a way that I say, now you've crossed the line.